Welcome to Casa Academy, Chapter 4, Part 4, where we will cover authorized relationships, duties, and disclosure. This is a truly foundational topic. It absolutely anchors your understanding of Florida real estate law. We're going to take the sheer complexity of the Brokerage Relationship Disclosure Act, and we're just going to break it down visually, piece by piece, so you are perfectly 100% prepared for your licensing exam.
So let's take a quick look at our visual roadmap for today. We'll be covering 1. Single agent relationships, 2. The employing broker, 3. In-house transactions, 4. The dual agency trap, and finally, 5. Transition to transaction broker.
Okay, let's dive right into this with Section 1, Single Agent Relationships, the highest level of responsibility.
So, a single agent is essentially the exact opposite of a transaction broker. Under Florida's Brokerage Relationship Disclosure Act, a licensee operating in this capacity is legally referred to as the agent, or single agent. The absolutely critical takeaway here is exclusivity. You represent either the buyer or the seller. Never, ever both parties in the exact same transaction. And the person you're exclusively representing, well, whether they're buying or selling, they are known as the principal.
Now, when you're acting as a single agent, you owe your principal some serious fiduciary duties. You literally must place the principal's interests above all others. It requires a high degree of trust, absolute loyalty, and the utmost care. Because of these heavy legal obligations, single agency carries significantly greater liability than other brokers' relationships. And hey, definitely keep this little detail in mind for your exam. You have to provide the single agent disclosure in writing to the principal before entering into a listing agreement or a representation agreement, or even before showing property, whichever of those happens first. But here's the kicker. While you absolutely must provide this written disclosure up front, the principal actually isn't required to sign it at this stage. Crazy, right?
So that brings us to a really fascinating structural question. Think about this. When a client walks into a real estate office, who actually represents the principal? Is it the friendly agent who greeted them at the front door, or is it someone else entirely? Well, the answer to this is honestly the key to understanding how brokerages actually operate structurally.
Which leads us right into Section 2, the employing broker, the true legal agent.
Let's see how this builds our understanding. As a sales associate, you work for your employing broker, right? Well, legally speaking, it's actually the broker, not you, who enters into the agency relationship with the principal. Yep, the employing broker is the true agent. Sales associates and broker associates, we merely act as subagents of the broker. Think of it like a massive umbrella covering the entire office. Because all licensees within the brokerage are working under that exact same broker, every single one of them owes the exact same fiduciary duties to that broker's principal. It's a total package deal.
Moving on to Section 3, In-house Transactions, when one roof covers two parties.
All right, let's walk through a super common scenario. You have an in-house transaction when one licensee in a brokerage, let's call them Associate A, is working with a seller. Meanwhile, another licensee in that exact same brokerage, Associate B, is working with a buyer who happens to be interested in that seller's property. Now, at first glance, it might seem completely fine. It looks like each associate is representing a different party. But remember that giant subagency umbrella we literally just talked about? Because both associates work under the same employing broker, the brokerage itself would effectively be representing both the buyer and the seller in the very same transaction.
To see exactly how this plays out, let's look at a concrete example. Let's suppose an office is going through a routine compliance review, and the auditor pulls transaction file number 987752. And actually, real quick, just for your lesson completion, your verification code is 200369. Okay, so back to our compliance file. If that review of file 987752 revealed that both the buyer and the seller were being represented as single agents through the exact same brokerage, well, that situation constitutes a massive, massive problem.
Which brings us to Section 4, the dual agency trap, strictly prohibited. So the crucial point here is that dual agency occurs when the same brokerage represents both parties as agents in the same transaction. We've already established that a single agent owes the highest degree of absolute loyalty to their principal. Now think about it. You logically cannot be absolutely loyal to a seller who wants the highest price possible and simultaneously be absolutely loyal to a buyer who wants the lowest price possible. It just doesn't work. Because of this impossible conflict, dual agency is expressly prohibited under Florida Statute 475. It is entirely 100% illegal in the state of Florida, no exceptions.
And that takes us to our final part, Section 5, Transition to Transaction Broker, the legal resolution.
And this brilliantly illustrates exactly how a brokerage can lawfully navigate their way out of that dual agency trap. The solution? You change the single agency relationship to a transaction broker relationship. This shift allows the brokerage to provide limited representation to both parties, effectively removing that impossible conflict of absolute loyalty we just talked about. But you gotta be careful, because specific, strict requirements must be met here. Step 1. The agent must provide the transition to transaction broker disclosure in writing. And step 2, which is absolutely crucial, you must obtain the principal's written consent by having them actually sign that disclosure.
Listen closely to this rule, guys, because it is vital for your exam. If the principal does not sign the disclosure, the single agency relationship remains in place. Earlier, we noted that the initial single agent disclosure didn't technically require a signature. But for a transition to actually take effect, this signature requirement is absolute. If they don't sign it, the relationship doesn't change. And if the relationship doesn't change, well, the brokerage cannot legally proceed with the in-house transaction, because doing so would instantly create prohibited dual agency. Basically, the whole deal is effectively paralyzed until that signature is secured.
So, to wrap this all up, single agency offers the highest level of fiduciary responsibility. But thanks to the subagent structure of a brokerage, representing both sides leads straight into a legal dual agency. Your only way out of that mess is a signed transition to limited representation. So I'll leave you with this question to ponder as you prepare to head out into the field. Will your next in-house transaction fall into the dual agency trap, or will you remember the structural boundaries we covered today and secure that vital transition signature in time? Thank you so much for focused learning with me today, and hey, best of luck on your exam.